an appeal in the matter of EJW Builders Limited and another, and Marshall and another.
Yes.
My Lord,
Ms. Harris.
I appear for the Appellants, EJW Builders Limited, and its sole director and shareholder, Mr. Eamon Joseph Wynne. They were the claimants in the underlying proceedings. My own friends, Mr. Brown Casey and Mr. Cock, appear for the respondents, who are Audrey Marshall and Edward Marshall. They were the first and second defendants in the underlying proceedings. There were two further defendants in the underlying proceedings, Mr. Wood and Mr. Vinicum. Those are the respondents' trustees in bankruptcy, but they took no part in the underlying proceedings. I think they were added for the purpose of disclosure only, and they take no part in this appeal. With introductions out the way, could I firstly just check that your lordships and your ladyship have an agreed list of legal propositions that was filed?
We do, yes, and we've got a core bundle, a supplemental bundle, and obviously the skeleton arguments. And I can reassure you that we've read, we think carefully, all the materials that we think we have to read. And that includes the core documents that you rely on as proving the case.
I'm grateful, my lord. Thankfully, this is not an appeal with a great deal of documentation.
It isn't. But the documents, as I understand it, you rely on as proving the case, notwithstanding the judge's rejection of the oral evidence from the only witness of direct fact.
Indeed.
That's the challenge for you.
That is my challenge.
Could you just enlighten us about the significance of the bankruptcy? Because, frankly, we're just wondering what this is all about.
My lord, it's a completely fair question. Obviously, these proceedings were issued before bankruptcy orders were made.
Yeah.
Bankruptcy orders followed the issuance and, I think, service of the proceedings. There was a hearing before District Judge Markland to determine whether permission should be granted for the proceedings to continue.
Sorry, I didn't catch that. Permission should be granted
for the proceedings to continue,
yes,
or whether they should be stayed under the relevant provisions of the Insolvency Act. District Judge Markland determined that the four issues that were before His Honour Judge Matthews should continue to trial, on the proviso that if His Honour Judge Matthews found that there was a contractual arrangement which gave rise to a debt or damages claim, the only way for my clients to enforce that was by way of proof in the bankruptcy.
Yes.
If your lordship's question is what is the point in these proceedings because the respondents are bankrupt, obviously we don't know what the bankruptcy is going to.
No, I mean obviously there's an advantage. It's just a question of whether that advantage is significant or not.
Yes.
In the context of the distribution, and we don't have, I don't think, the figures, and I'm not inviting a discussion about that. We just want to get the overall picture clear.
It may also be, and I hinted at this in, I think, closing submissions before His Honour Judge Matthews, if this court on appeal finds that there was a partnership, there may be alternative proprietary routes to recovery. Again, I don't think I need
that had floated across our minds, but anyway, that's helpful just to get a bit of context. Thank you.
I'm grateful. So as your ladyship and your lordships know, this is an appeal from the order of His Honour Judge Matthews, which in short dismissed the claim and made a pro bono cost order against my clients. To summarise the claim very briefly, my clients allege that there was a partnership or alternatively a joint venture agreement between both or either of them and Mr. and Mrs. Marshall in relation to the development of Hilbury Court Hotel in Trowbridge. That property was to be converted from a hotel into 4 houses, 3 in the existing building and a new build adjoining house. The principal factual allegation by the appellants was that it was agreed between the appellants, or either of them, and the respondents that they would receive a 1/3 share of the net profits from the development upon the sale of the houses. With respect to remedy, the appellants claimed an account, should the court find that there was a partnership, or their net profit share as a contractual debt or damages. The transcript of the judgment is in the core bundle at page 29. I don't think I need to turn to it quite yet, but just to summarise the learned judge's principal findings at trial, they were firstly that there was no partnership because there was not a single business a core part of the definition of partnership. because the appellants did not assume any personal liability or take on any personal risk. And finally, that there was no holding out to the world as a partnership. And the second principal finding was that there was no profit share agreement, that the only contractual document relationship between the parties was the JCT contract. That contract is dated the 17th of June 2019. It's in the supplemental bundle. Again, I don't think I need to turn to it at this stage.
Signed about a week after the works.
Indeed, my lord, yes, but pretty much exactly a week. Permission to appeal was granted by Lord Justice Nugie on 5 grounds. Those grounds of appeal fall into 2 parts. Firstly, grounds 1 to 4 challenge the factual findings made by the learned judge at first instance on various bases, that they were unsupported or contradicted by the evidence, that documents were not properly taken into account on the basis that they originated from the appellant's side, that the learned judge misunderstood relevant and important documentary evidence, and finally that there were conclusions reached by the learned judge that in my submission no reasonable tribunal would reach on the evidence. Ground 5 relates to the finding of there being no partnership. That is a mixed question of fact and law. I propose to divide my submissions into 3 main parts. Firstly, I will make some preliminary comments about the relevant test before this court and the role of an appeal court on an appeal of fact. Secondly, some preliminary comments on the learned judge's findings about the oral evidence, and in particular the oral evidence of Mr. Wynne. And then some preliminary comments on the importance of the Guestman direction given by the learned judge. The second part of my submissions will be the most substantive part, and that will address grounds 1 through 4, and the question of whether the learned judge was wrong to find that there was no profit-sharing agreement. And thirdly, I will address ground 5, and whether the learned judge was wrong to conclude that there was no partnership. I think it is fair to say that ground 5 is parasitic on grounds 1 to 4 succeeding, it being a fundamental plank of the appellant's case, and indeed the definition of partnership, that there was an agreement to share profits.
Yes, there's got to be an agreement that goes beyond the JCT contract.
Indeed.
Of some kind.
Yes, my lord.
Now you've set out the framework, have you reached some agreement about the allocation of time?
I did
It did strike us we've got a day and a half for this, which
yes, my lord, which I think
rather
is
generous.
Yes. I had hoped to be finished by the lunch adjournment, which gives my learned friends the afternoon to make submissions. I don't know the extent to which I will have very extensive reply submissions, but it may be we can finish today, or if not, tomorrow morning, my lord.
Well, we'll see how we go. And it seems, as I say, we've read the documents, so you're not going to need to take us through the less contentious documents, but probably focus your attention on the ones that you say are critical to the decision making.
With that indication, for which I'm grateful, my lord, I wasn't going to deal with the factual background as a standalone point in any event. Given this is an appeal of fact, I will take your ladyship and your lordships through the relevant facts as I deal with grounds 1 to 4.
Yes, thank you.
So the preliminary comments. The role of this court, and I accept, this appeal isn't and cannot be a simple rerun of the trial. The learned judge, of course, saw the witnesses, weighed their evidence, and was immersed in the courtroom atmosphere. In the agreed list of propositions, your ladyship and your lordships has extracts from Biogenink and Mediva PLC and Farhay UK Limited and Chobani, which both set out the relative sanctity of a decision at first instance. But of course, this court can overturn findings of fact that are, to quote, plainly wrong. And examples of when a factual finding will be plainly wrong are given in Walter Lilly & Co Limited and Klin. That is at page 93 of the authorities bundle. And then at paragraphs 86 and 87, there is a bulleted list of examples of when a factual finding be plainly wrong. These include where a judge has plainly failed to take evidence into account, where a judge has arrived at a conclusion.
Sorry, where are you reading from?
It's 85.
It's the bulleted list, my lady, at paragraph 85, page 116 of the
Thank you.
authorities bundle. So yes, examples: plainly failing to take evidence into account, arriving at a conclusion which is not supported by the evidence on any view, making a finding outside of the bounds within which reasonable disagreement is possible, and then into paragraph 87, where there is an identifiable flaw in the trial judge's treatment of the issue in question. Examples given there are where there's a gap in logic, a lack of consistency, or a failure to take into account a material factor.
Oh, so that's 86, yeah.
Yes, my lord.
Yes. And you say there are examples of all of these errors in the findings here.
Indeed, my lord. Well, that is what I hope to persuade you
Yes.
in relationship of. There is also relatively trite now guidance as to appeals of fact in Volpe and Volpe. There is a quotation from that in the agreed list of propositions at number 8. I don't think I need to take your lordships and your ladyship there. Moving then to the oral evidence at trial, the learned judge of course concluded that he was unable to rely on Mr. Wynn's evidence except where it was corroborated by an independent and objective source. As my learned friends rightly note in their skeleton argument, that finding is not challenged on this appeal. But I obviously do not accept my learned friend's contention that that finding as to Mr. Wynn's oral evidence is fatal to this appeal. And my submission in this case does not turn on oral evidence alone, and whatever the criticisms of Mr. Wynn's evidence, he was steadfast in his position that there was an oral agreement to share profits, followed by attempts to record that agreement in writing.
Yes, well, the judge found that he believed that to be the case.
Yes.
So that's also not challenged by the respondent. So we proceed on the basis that he believed there was an agreement, but that there wasn't, according to the judge. So it's the second bit that really matters.
Indeed, my lord.
Yeah.
And just to make two short points about the adverse credibility finding, it was not that the learned judge thought that Mr. Wynn was lying. In fact, he thought that all of the witnesses were telling the truth or not deliberately telling him any untruths. His observations about Mr. Wynn was that he was, to quote, unsophisticated, had a very poor recall of events and appeared to be confused. I don't disagree that that was a fair assessment of Mr. Wynn's evidence. And of course the learned judge was prepared to accept Mr. Wynn's evidence where it was corroborated. And the simple point on this appeal, which I will obviously expand on, is that that core steadfast belief of Mr. Wynn, not that belief is relevant to the question of whether there was an agreement, but that core steadfast belief is corroborated by the documents. Which leads me to the importance of the documentary evidence and the Guessman direction given.
When you say core steadfast, is that a quote from the judge, or is that your
No,
characterisation?
that's my characterisation.
Because the judge did make a few points about inconsistencies between the case advanced at different points. So steadfast might not be a fair characterisation of what the judge thought about it.
There was certainly inconsistency with respect to the case presented on the written JCT contract.
Yeah.
But it went beyond that, didn't it? Didn't it go to, for example, who were the other parties to that partnership or profit-sharing agreement? With whom the split should be?
Lady, I accept there is some difference on the documents as to whether Mr. Lucas was part of the partnership. I say for these purposes, the important fact is that it is consistent that Mr. Wynn was to receive a 1/3 profit share.
Whoever he got it from.
Whoever
it came from.
Indeed, my lord.
Yes.
The learned judge's direction as to documents is found in paragraphs 13 and 14 of the judgment transcript, which is page 32 of the core bundle. What the learned judge observed, and I don't think this is controversial, is that memories can be faulty. In commercial cases, and he found this to be a commercial case, judges prefer to rely on documents as being more objective evidence. Documents are important and useful, whereas in this case, the relevant events took place over several years and time has elapsed since they took place. And finally, that the learned judge would therefore give appropriate weight to both the documentary evidence and the witness evidence, bearing in mind the fallibility of memory and the relative objectivity of the available documentary evidence.
So you don't criticise that as a self-direction?
No, my lord.
I think your case is that he didn't abide by it when it came to looking at the documents.
Indeed, my lord. We say it was entirely right for that direction to be given. This was exactly the sort of case where, in reaching factual findings, primacy ought to have been given to the documents and known or probable facts. And that is for three reasons. As was observed by the learned judge, by the time of trial in late 2025, the agreement that was alleged by the appellants and the start of the works at the hotel had happened some 6 years previously. All of the witnesses' oral testimony was, quite understandably, replete with admission of lack of recollection. And although not voluminous as I've noted, there were, as the learned judge observed, several useful contemporaneous documents, including correspondence both passing between the parties or their representatives and between the parties and third parties. And I don't believe there is any dispute between myself and my learned friends as to the importance of documentary evidence generally and in this case. Your Ladyship and your Lordships have in the agreed propositions of law at number 1 a passage from the Ocean Frost which explains the utility of referring to objective facts and documents, particularly where the court is faced with conflicting oral evidence.
But the court can't ignore the oral evidence where what's alleged is an oral agreement.
My Lord, I entirely take that point.
Doesn't the judge have to weigh up everything in the round, the objective facts, the documents, the inherent probabilities, the oral evidence, who he believes, all of those factors, and come to an overall assessment?
Yes, my Lord.
I mean, I would personally question this idea that you can give primacy to any one strand of evidence as a matter of principle. It all depends on the case.
My Lord, yes, and in the reasons I just outlined in my submission, this was a particular case, not least because of the passage of time, and clearly the witness is not being able to fully recollect events. This was an appropriate case to have particular regard to the documentary evidence. I'm certainly not submitting that the documentary evidence is the only element of the evidence that the learned judge had to consider, but as I will go on to submit, there was a discounting or failure to properly understand and consider documentary evidence, which in my submission is important, particularly given the failure of memory of the witnesses. I will return to this case, but in the authorities bundle at page 67 is Symmetra Global Assets Limited and Icon Finance Limited, and I would draw the court's attention in particular to paragraphs 48 and 49 on page 75, which deal with the importance of contemporaneous documents. Moving then to, as I said, the most substantive part of my submissions, which is addressing grounds 1 to 4 and the factual finding that there is no profit-sharing agreement. As I said, the learned judge's conclusions, which are in the core bundle at page 39, paragraph 63 to 65, were that there was no profit-sharing agreement and that Mr. Wynne had simply wrongly persuaded himself that the respondents were willing to share profits, and later that a profit share had been agreed. and that the only contract between the parties was the JCT contract. Grounds 1 to 4, as I've said, are all concerned with that conclusion as to there not being a profit sharing agreement. And as was noted in the permission to appeal decision by Lord Justice Nuji, the grounds really run together. Ground 1 is that critical findings of fact were unsupported or contradicted by the evidence, such that the learned judge was wrong to reach the conclusion he did. And there is a particular focus on the following findings. Two areas. Firstly, what I've termed the implausibility findings. There are three of those. Firstly, that it was implausible that a profit-sharing agreement would have been reached between the parties by early February 2019. Secondly, that it was implausible that the respondents would agree to share the profits of the development at all. And finally, that it was implausible that the appellants would be remunerated by way of the build cost, a salary for Mr. Wynne, and a share of the profits. My submission today is that those findings were evidentially flawed because of either an absence of evidence or the existence of contradictory evidence or factual findings made by the learned judge. The second area of findings focused on by ground 1 is what I've termed the self-deception finding, that Mr. Wynne had convinced himself of the existence of an agreement that had never been reached. My position is that no reasonable tribunal could have reached that conclusion on the available evidence. The second ground 2, is concerned with the learned judge's wholesale discounting of documents on the basis that they came from the appellant's side. The appellants say that that was not a sufficient basis upon which to reject the documentary evidence, and that had those documents been properly considered, then the learned judge would not have reached the finding that he did. Ground 3 is concerned with what, in my submission, now are misunderstandings of several pieces of documentary evidence relied on by the appellants and the factual findings that arose as a result. And finally, ground 4, I accept is something of a wrap-up ground. The appellant's position is that the overall conclusion reached by the learned judge on this issue is not one which any reasonable tribunal would reach, having regard to all the evidence, and in particular the documentary evidence. My approach to submissions is going to be chronological. I hope that is of assistance. I propose to take the court through the relevant events, covering both the undisputed and the challenge findings of fact, and expand on grounds 1 to 4 as I do so. But as I say, I will treat them as running together.
Yes, I think that'll be helpful. Thank you.
So the first period of time is the period before the works start on the 10th of June 2019. The background to what led to the work starting is set out in the judgment on pages 33 to 34, paragraphs 22 to 24 in the core bundle. Essentially, by the time of trial, it was not in dispute that there was an initial plan from around September 2017 for a Mr. Stephen Bygrave to outright purchase the hotel for a price of £750,000 and to then develop it using the appellants as the builders on the project. Planning permission was obtained for the development in November 2018. And it's expressly stated on the face of those planning documents, which are in the supplementary bundle, but I don't think I need to turn them up, that the development works had to begin within 3 years of the date of permission being granted. And at some point, and I will come on to which point, Mr. Bygrave ultimately decided not to proceed with purchasing the hotel. That leads me to the first implausibility finding by the learned judge, and that is the finding which is on page 34 of the core bundle at paragraph 28. there, the learned judge found that, firstly, the respondents did a lot of thinking before they decided to proceed, and secondly, that it was implausible that they would have agreed to share the profits with the appellants just a day or two after Mr. Bygrave pulled out. Now, I say that the learned judge made a chronological error here. He found as a fact that Mr. Bygrave pulled out of the project or the plan at the beginning of February 2019. Your Lordship and Your Ladyship have that in paragraphs 23 and 28 of the judgment, pages 33 and 34.
23 and
Paragraph 23 and 28.
28, yeah.
In my submission, that finding was not supported by the evidence. If I could ask Your Lordships and Your Ladyship to turn up page 54 in the supplemental bundle. We are in Mrs. Marshall's witness statement. Paragraph 15, the final two sentences, state that in early 2019, around February, with the caveat I'm not entirely sure why, Mr. Bygrave decided not to proceed. And then what follows in paragraph 16 is that the respondents then started looking at financing options to pay for the conversion works. That sequence is, in my submission, entirely logical. There was no need for the respondents to obtain finance to fund the works under the original plan, as Mr. Bygrave was simply going to buy the hotel outright. The learned judge then had...
Is it apparent, you said it was common ground, that the claimants were going to do the work under the original Bygrave proposal, and as I understand it, it's uncontentious that explains why the claimants got the costings
Yes,
that
Lady.
they did. It was, and that's the basis on which one assumes they would have been remunerated by Mr. Bygrave, or is that an unfair assumption?
No, Lady, I think that's an entirely right assumption. The chronology of the transaction would have been that the respondents would have sold the hotel to Mr. Bygrave, who then, of course, would have been the absolute owner, would have been free to do with it what he wished. And I understand, because of the existing relationship, he had lined up the appellants to be the builders to do the development work.
I mean, what's going through my head, and this rather illustrates the point that an appeal court can't be put in the position that the judge was in. The judge was faced with a situation where a builder was going to do work in the normal way for the purchaser, Mr. Bygrave, who was seeking to make a profit from the development. And this goes more to implausibilities than anything else. Why should it be such a different arrangement when, as far as the claimants are concerned, when Mr. Bygrave pulls out?
My lady, it's a point I will come to. What I will say is that the costings were cost price. This is the cost for the labour for the work. Obviously,
well, you say cost price, but we all know that if I employ my builder, to do some work on my house, he's not just charging me what he needs to pay his subcontractors.
Indeed, my lady, and that is precisely the point. We don't know what Mr. Wynne or the EJW builders would have charged Mr. Bygrave for the works. What the appellant's case at trial was that costing figure, the figure that ends up in the JCT contract of £825,000, was pure cost price with no profit.
Sorry, whose evidence was that?
That was the appellant's evidence. That was their case, and I will take your ladyship and your lordships to that evidence.
Right.
This was the quantity surveyor who came up with a figure that was only cost.
Yes, my lord.
Okay.
Why would that be So when they're giving the figures to Mr. Bygrave?
Well, as I said, I don't know the extent to which there were conversations with Mr. Bygrave about how much would be charged for the job. The costings were obtained because they were obtained. They were then used to put a price into the JCT contract. My client's evidence was that that was cost price.
Right.
And the profit element therefore came from the share of the net profits rather than on being
Well, we've
charged.
taken you out of your course. You were telling us why it was a mistake. It was a chronological mistake.
Yes.
For the judge to find that Mr. Bygrave pulled out in early February 2019.
Yes, my
You
lord.
started by taking us to a paragraph of the witness statement of Mrs. Marshall, which seemed to support that finding.
Yes, what I wanted to do, my lord, was establish that the chronology was Mr. Bygrave pulling out and then attempts to obtain finance, because there was no need to obtain finance before Mr. Bygrave pulled out.
But you're not challenging the judge's finding that he pulled out in early February?
I am on the date, yes, my lord.
Where is that in your grounds of appeal or skeleton argument? I only raise that because I can't remember this point being taken as a separate point challenge.
I can check. It's paragraph 16 of my skeleton argument. Deals with the finding that the alleged timing of the alleged agreement was implausible.
Sorry,
I'm afraid
I can't see it.
I've read that
Yes.
previously and I didn't pick up this.
I read that as accepting the judge's finding, I have to say, that that was when Mr. Bygrave pulled out, as a matter of fact.
Yes, indeed, you've said at around the time Mr. Bygrave was having second thoughts.
It may not be that it overly matters. I was going to move on to if the judge was correct. That
Well, I think what the judge was doing, and this may be, we may be at cross purposes here, the judge is contrasting the claimant's case with what he found to be the facts, isn't he? In the judgment, he's saying, if I can find it now, lost it. He was saying, well, their case is that the joint venture agreement was made in February of 2019. I don't find that's plausible because Bygrave had only just pulled out and there was a lot more to do.
Yes, my lord. So what I wanted to do was to challenge this specific within a few days. If that is not open to me, I will.
So I thought the argument in paragraph 16 looked to me, at least, to be, well, there must have been something agreed between then and the JCT contract, which
Yes.
is obviously right. There must have been something, because they can't have entered into the JCT contract without some prior idea of what they were going to do.
That is what I will come on to.
Yeah.
I'm in your lordship's and your ladyship hands.
Well, I don't think we're going to stop you. We're just exploring what the point was.
Yes, and I will come, my lord, to the bigger point, which is if the learned judge was correct, it was only a matter of days. He was still wrong to find that it was implausible that the agreement would be reached. I will just finish this point about whether it was.
Well, I was just for your own understanding. I was looking at paragraph 25 of the judgment, where the judge. This is what this judge's starting point, what he's addressing. Claimants say there was an agreement by early February 2019 or by 8th of February at the latest. And so he's contrasting that with the evidence he's got from Mrs. Marshall, that was pretty much the point at which Mr. Bygrave pulled out.
Yes,
so that's where he gets his days from, isn't it?
I will come to where the days come from.
Okay.
I just wanted to take your lordships and your ladyship to some WhatsApp messages that
Yes.
were before the learned judge at page 2. And these are WhatsApp messages between Mr. Wynne and Mr. Bygrave. So where a message is shown as sent, it is sent by Mr. Wynne. Where it is shown as received, it's received from Mr. Bygrave. And I just wanted to flag to your lordships and your ladyship the message on the 30th of January 2019 at 17:17.
So where are we in bundles?
Page 273 of the supplementary bundle, my lord.
273.
273, yes, my lady. And it's the fifth message from the bottom of the page, 30th of January 29 at 17:17. And it's a message from Mr. Wynne to Mr. Bygrave, requesting that Mr. Bygrave drop off information obtained from Mrs. Marshall regarding the hotel price. And then he says, Ian, Mr. Lucas, needs it for a lender tomorrow. Plainly, that message is stating that a meeting with a lender has been arranged for 31st of January 2019.
So are you asking us, were it open to you, were you going to say that means that Steve had already backed out by then?
Yes, lady, that we're not necessarily thinking about 1 or 2 days. I accept it might not be that much longer than that, but certainly it appears that there were discussions with lenders arranged on or before the 30th of January, which is strongly indicative of Mr. Bygrave having already pulled out at that point. And these are not messages that were contained in the judgment.
Yeah. Okay.
As we know, at page 278, and this is a WhatsApp message I will come back to, but this is a message sent, these are WhatsApp messages between Mr. Opie, the mortgage broker, and Mr. Wynne.
278.
278, yes,
Yeah.
my lord. And it's the second message on that page, the 8th of February message, which has some importance, and I will come back to it. But this is where the pleaded date of 8th of February 2019 arises from, because it's at the conclusion of this message that Mr. Wynne says, my involvement in this is I have the build cost plus to share in the profits. And Mr. Lucas accepted in his oral evidence at trial that the reason why Mr. Wynne was sending this message was to enable finance discussions between Mr. Opie and Respondents following Mr. Bygrave pulling out.
So that it's the last sentence of this, which we've seen before elsewhere, which is a critical part of the
It is,
evidence.
and I will be
But
coming back
this
to
gives
it.
us the full context, which I don't think I've read before. Thank you.
And just the final factual point on this point, insofar as I can run it, page 85 of the supplemental bundle, in Mr. Martin's, Matthew Martin, the solicitor at Converse Law, his witness statement, his final sentence of his paragraph 9 at the top of the page is that Mr. Bygrave had then decided to pull out of the project in around January 2019. So that, my lady, is my first point, that we are not necessarily dealing with 1 or 2 days before Mr. Bygrave pulling out in the 8th of February.
But there's not a big difference on any basis, is there?
No, my lady. So that leads me to my second point, that even if the learned judge is right about it being 1 or 2 days, that finding is nevertheless unsafe, because it ignores or is contradicted by evidence and the learned judge's own findings. The position that the respondents found themselves in, as the learned judge rightly observed, is that after over a year of negotiations with Mr. Bygrave and planning permission having been granted in November 2018, the respondents were, to quote the learned judge, back at square one following Mr. Bygrave losing interest. The learned judge had also held, and this is paragraph 21 of the judgment on page 33 of the court bundle, that the respondents have been looking for an exit from the business since at least 2017. What was not before the learned judge was any evidence, either from the respondents or any other person, that there was an alternative proposal on the table at the time. There was no evidence that the respondents sought to market the hotel in early 2019, or that they were speaking to any other proposed purchaser. In my submission, an arrangement directly with the appellants, who of course were already lined up to do the works under Mr. Bygrave's instruction, had the sale proceeded, was the only available alternative option. And I think the learned judge did recognise that in part in paragraph 24 of the judgment on page 33. As your lordship has noted, clearly an agreement was reached at some point before the works started on the 10th of June 2019. I think that was accepted by Mrs. Marshall in cross-examination. The learned judge also appears to have found that an arrangement was reached between the parties before work started, pursuant to which the appellants were engaged to undertake the building work. That is page 34 of the core bundle, paragraphs 30 and 31. Paragraph 31 begins with, at all events, it was arranged that the builders would arrive to start work on the 10th of June. It's implicit in that there were discussions about work starting and an agreed start date. It was common ground that there was an agreement that the respondents would pay a salary to Mr. Wynne. If your lordships and your ladyship turn up the JCT contract, which is in the supplemental bundle, it starts at page 301. And I'd like to take your lordships and your ladyship to page 304, which deals with the price. The price stated there is £825,000. There is no mention in the JCT contract of any other sum than the first price. No salary. So it must be right that what was agreed between the parties extended beyond the scope of what was in the JCT contract. Notwithstanding that, the court was not assisted by any written or oral evidence from the respondents about discussions, negotiations, agreements with the appellants in the period before the work started. Their witness statements were completely silent on that point. And in cross-examination, both Mrs. Marshall and Mr. Lucas's evidence was that they had no memory of discussions. I can take your lordships and your ladyship to, I think it's fair that I do so, take you to the transcript of their evidence. So Mrs. Marshall is page 177 of the supplemental bundle. My questions begin at B.
So could you give the reference again?
177, my lord, of the supplemental bundle. And my question at B is essentially the point I've just made. There must have been discussions before the work starts.
Is this Mrs. Marshall?
Mrs. Marshall, yes, my lady. And Mrs. Marshall says there was an agreement he was going to start with a new build. I asked when the agreement was reached, and she said it was before they actually came in on the 10th of June. Then I ask if anything else is agreed or discussed, and she says, I can't recall.
You said earlier that it was common ground that a salary was agreed. Is that evidenced somewhere?
I can find the reference, my lady, certainly in the, of course, one of the key findings of the learned judge is that it was extraordinary that the appellants would be remunerated by way of build costs, salary.
No, but that wasn't my question. Where's the evidence or procedural agreement? Is it in the pleadings? By the way, I couldn't find the reply.
The reply is in a supplemental bundle, my lady.
Okay.
That's page 14. And I am relatively confident. I'm just word search that salary is referred to in the witness statements of Mrs. Marshall. So as an example, milady, I'm actually in the witness statement of Mr. Lucas, but page 71 of the supplemental bundle, paragraph 25, there is a discussion about salary being paid to Mr. Wynne of £1,500 a week. It simply says that that was paid. There's no discussion of when the agreement was reached.
That's Lucas, is it?
Yes, lady. And then just to complete the point about the absence of evidence from the respondents about discussions pre-works, I was going to take your lordships and your ladyship to page 149 of the supplemental bundle, which is Mr. Lucas's cross-examination. And at B, I ask, did you have discussions with Mr. Wynne in person in 2019 before the work started? And the answer is, I don't recall. And I ask for clarification, they did not happen or you do not remember. And the answer again is, I don't recall. So there was certainly no positive assertion by the respondents that there had been no discussions. Moving forward in time, as we know, the work started on the 10th of June 2019. The JCT contract was signed a week later on the 17th of June 2019. I want to turn now to the documents that relate to the appellant's instruction of Mowbray Woodward's solicitors in June 2019. And just to take your lordships and your ladyship through those emails. The first in time is on page 312 of the supplemental bundle.
So just to orientate ourselves, on the claimants, the appellant's case, there has already been, by this stage, an agreement for a profit share.
Yes, my lord.
Between the claimants, or one of them, and someone.
And the respondents.
One or
possibly
both
acting
the respondents.
Yes, by 8th of February 2019, my lord.
Yeah.
And I was taking your ladyship and your lordships to page 312, email at the very bottom of the page, on the 13th of June 2019. Kelly Pierce was a secretary. She worked for both Mr. Wynne and Mr. Lucas, but was paid by Mr. Lucas. That was confirmed to Mr. Lucas's evidence. And what the email is at the bottom of page 312 is a draft prepared by Miss Pierce for Mr. Wynne to send to Mowbray Woodward solicitors, and that is apparent from the subject line for Mowbray, and the fact that the next email up the chain on the 24th of June is Mr. Wynne forwarding that email to Mowbray Woodward solicitors. This email, prepared by Miss Pierce on the 13th of June, is 3 days after the works began and 4 days before the JCT contract was signed. And then as we have to go up the chain to go forward in time, as I said, that email from Miss Pierce was forwarded to the solicitors on the 24th of June. There is then a response from Mr. Phillips the next day, and then it appears to be put in someone else's hands, Jeanette Woodland, who again responds on the 25th of June.
This one's got 4 people interested in the profits. If this is right, the respondents get a third, Mr. Lucas then gets a third, and Mr. Wynne gets a third.
My Lord, yes, it's the point that was raised earlier in this hearing, that there is some difference in the documents as to whether Mr. Lucas is part of the partnership. But what is consistent is that Mr. Wynne or his company receives a third, and that is what matters for his purposes in my submission.
Well, it's what matters, but what we've got to, or what the judge is tasked to do, was to work out whether there was an agreement.
Yes, my lady.
And legal agreements normally require at least identification of the correct parties.
Yes, my lady. For the joint venture proposition, if there was an agreement that my client receives a third of the profits, then there was an agreement that my client receives a third of the profits. As Maud says, it matters not on construing whether that was a concluded agreement and its terms, what happened with the remainder of the money retained by the respondents. I accept the issue is a little more knotty when considering partnership.
But it goes to, it seems to me, to the question whether there's really an agreement at all, because essentially what the judge found was that, yes, there were a series of discussions over quite a long period of time, but those were all effectively proposals. They may have been subject to contract, but they never reached a conclusion. And one of the factors one might think was relevant in deciding whether there was an agreement at all was who was even involved in this proposed contract.
As I say, my lord,
It's not really about how you construe the contract if entered into. I understand your point on that. It's more a factual question. Was there a contract at all?
and if one is looking at this from the contractual perspective, not the partnership perspective, you have the respondents who own this property and are doing the works, and my client's case is that they agreed to give me a third of the net profit. In my submission, it wouldn't prevent a contract being performed if there was doubt about how the respondents were going to deal with the balance of the money generated from the development. Whether that was paid to Mr. Lucas, who of course is Mrs. Marshall's son, or not, wouldn't prevent, in my submission, the conclusion of an agreement between the appellants and the respondents.
Well, and then there's the other side of it. You said the appellants, and this document, the one that starts this chain, doesn't refer to the company, it just refers to Mr. Wynne.
No, my lord, and that is why there was some bifurcation in the way this case was pleaded. This court will undoubtedly be familiar with one-man band companies as a sole director, sole shareholder company.
Yeah, but I mean, people who set up those companies are usually very well aware of the significance of the difference between individual and corporate personality. That's why they do it.
This obviously became blended, as I'll come to, became blended throughout with Mr. Wynne prepared to put up personal security. Yes, and I don't think the learned judge was particularly concerned by a lack of distinction between Mr. Wynne.
But can I just go back to Mr. Lucas for a moment, because you've just explained why you pleaded in the alternative between the first and second claimant, but as far as I can recall, you didn't plead an alternative case involving Mr. Lucas.
That's correct, my lady.
And you didn't try to pursue that case. The case run at trial was one third to Mr. and Mrs. Marshall as to 2/3.
1/3, 2/3 to
Yeah,
yes.
Mr. and Mrs. Marshall as to 2/3, I
Yes.
should say, and your clients as to 1/3.
Yes, my lady. I was taking your ladyship and your lordships through the emails to Mowbray Woodford. I think I'd got to page 311, and the email sent by Miss Pearce on the 25th of June 2019 to Janet Woodland. That email gave some more detail about the split, who the owners were, and as your lordships and your ladyship has noted, includes Mr. Lucas in that. It explains that Mr. Wynne is the main contractor for the sum of £825,000 and refers to the signed JCT contract. Then states the three parties are going into the project together. Once the project is completed and all outgoings bills have been settled, there'll be a split of the profits 3 ways, and then a request for that to be put into a contractual agreement. I'll come back to what these means and what these mean and what the learned judge should have done with them. I just want to complete the chronology of correspondence.
Yeah, thank you.
So
that's the 25th of June.
That's the 25th of June, my lord. There is then a lengthy reply from Miss Woodland on the 2nd of July. That's at page 315.
Yes, the judge thought there was no response to that, is that? We certainly don't have a response to that.
My lady, I'll come to what happened next in the chronology. But yes, there is no specific response to this email, that is right. That is sent on the 2nd of July. And then 2 weeks later, page 320, is a letter from Miss Woodland informing Mr. Wynne of her departure from the firm. And explaining that the matter will then be taken on by a Mr. Leslie Lawrenson. What comes next in time on the next page, 321, on the 26th of July, is an email from Mr. Lawrenson to Mr. Wynne referring to a telephone conversation they had yesterday, and then arranging a meeting at the hotel on the 5th of August. And Mr. Lawrenson states that the purpose of the meeting will be for us to discuss the documents required to protect your position regarding the proposed development works and profit costs, and also for you to hand over some papers. We know the meeting took place on the 5th of August, and the follow-up from Mr. Lawrenson on page 322, apologies, the next page, on the 7th of August, refers to the meeting that took place on Monday. And this is the end of the Mowbray-Woodward correspondence. The learned judge's treatment of this correspondence is on pages 35 and 36 of the core bundle, at paragraphs 34 to 37. Correspondence that I've just taken your lordships and your ladyship to, and then the learned judge's findings in respect of the import or otherwise of that correspondence are on page 38, paragraph 56.
Yes, just on that, when you get to 56, by that stage he said there's no partnership. So the earlier discussion of the documents, was that in the context of the no partnership?
No, my lady. The partnership, the partnership paragraphs come, as you say, fairly early on.
Oh, okay.
The earlier paragraphs are just reciting the factual history.
I see. So yes, it comes to the question of whether there's a partnership at 49. And then profit sharing agreement at 55.
Yes, there is, in detailing the chronology of that correspondence, there is, at the top of page 36, continuation of bottom of page 35 in paragraph 37, there is a finding in relation to the 7th of August email That is a finding that is picked up later in the judgment, essentially that it showed that something was being sought and discussed, but doesn't show a concluded agreement. And then at paragraph 56 on page 38 is the finding that the first 4 documents, which includes, in the list above, which includes Mowbray Woodward's correspondence, expressed only the appellant's view of what was going on. I'm going to deal with the finding that certain of the documents are partisan and what I've termed the self-deception finding as a block once I've finished going through the chronology, so I'll return to that point. But I will address the finding that is in paragraphs 37 and 57 about the email of the 7th of August, which is Mr. Lawrenson's response to Mr. Wynne following the meeting on the 5th of August. The learned judge held that that was an email that was difficult to understand, and as I've said, that it showed that only that the appellants were seeking something extra and not that an agreement had already been reached. With respect to that finding, in my submission, the learned judge's difficulty in construing that that email was and is not understood, and in further, the finding that the correspondence with Mowbray Woodwards is not compelling evidence supporting the appellant's case is wrong. To put the 7th of August 2019 email in context, we know from the chain of correspondence that from at least the 13th of June, which is the date of Miss Pearce's draft email, the appellants were willing to and did expend time and money in instructing solicitors to draft a profit-sharing agreement. We know that a meeting was arranged on the 5th of August 2019 at the hotel. We know the purpose of that meeting because it was set out in Mr. Lawrenson's email. It wasn't to negotiate the basis of the appellant's remuneration, but was, to quote Mr. Lawrenson again, to discuss the documents required to protect your position regarding the proposed development works and profit costs.
Where are you quoting from there?
Page 321.
321, that's the email setting up the meeting.
Yes.
That's what Mr. Wynne thought it was for. That's not evidence that that's what everyone thought it was for.
I will come, my lord, to what I say the 7th of August 2019
Yeah.
now shows as to Mr. Lawrenson's understanding was the meeting.
321 shows, is capable of showing that that's what Mr. Wynne and Mr. Lawrenson understood the purpose of the meeting to be.
Yes, my lord.
Yeah, it also reads to me as proposing a solicitor-client meeting, whereas the meeting that actually occurred had at least
yes,
Mrs. Marshall there as well.
It was
anyway.
Attended.
That may be a small detail.
To finish my context, but
Yeah.
yes, as the relationship says, the meeting was attended by Mrs. Marshall, albeit that she didn't remember that meeting at all, so could give no evidence about it. So, turning then to the 7th of August email itself, which is on page 322, supplemental bundle. We see from that email, and it's the 4th paragraph, Mr. Lawrenson records that during the meeting he mentioned that the document that he anticipated drafting was a joint venture agreement. I entirely take your lordships and your ladyship's point that the earlier email as to the purpose of the meeting derives from an understanding given to Mr. Lawrenson by Mr. Wynne. But what is clear from this email is that at the meeting attended by Mrs. Marshall, Mr. Lawrenson stated, I anticipate drafting a joint venture agreement. What Mr. Lawrenson doesn't say in his 7th of August email is, oh, Mrs. Marshall appeared very surprised at that suggestion, or Mrs. Marshall rejected the notion or the need for me to draft a joint venture email. His actual conclusion is second sentence of that paragraph, 4th paragraph. I still believe that this is the arrangement that you should be looking at, subject to reputable tax expert advising. So Mr. Lawrenson goes into that meeting understanding the purpose to be to document an agreement relating to the profits. He states in the meeting, I anticipate drafting a joint venture agreement.
Well, when you say document, it's a little ambiguous. I mean, is there something in this email that reflects what the appellants say was the existence of a prior agreement? Or is this not equally consistent with a wish to create an agreement for the first time to protect the position of the appellants?
Well, this is why I spent some time putting this in context. We know that this meeting is a culmination of a chain of emails that began on the 13th of June, so 3 days after the work start, where the request is for solicitors to draft a profit share agreement. And that, in my submission, reflects back to what my client consistently said was an all agreement reached before the work started.
But within the email, there's nothing that assists on that, really, is there? I can see your point about the context.
Yes,
that's why he's doing it, because they've started on the works and he wants extra protection.
There's nothing here that expressly says, you have told me that you reached an all agreement in February and now I am documenting that. Yeah. I accept that. In the judgment, the land judge didn't engage with this statement by Mr. Lawrenson. I still believe that this is the arrangement that you should be looking at. He's, of course, a solicitor. This was his contemporaneous view of the arrangement between the appellants and the respondents, having met with both Mr. Wynne and Mrs. Marshall. And it's my submission, the statement isn't difficult to understand. And the learned judge doesn't engage with why Mr. Lawrenson's view that is the contract that should be drawn up did not support the appellant's case and was not evidence that could be taken at face value.
And this is advice being given by the solicitor to his client, saying, I still believe that you should be looking at this arrangement. That's what it says. It doesn't say at the meeting the respondent agreed anything. There seems to have been some proposals about this so-called gift. But this is him advising his client, isn't it? And his client clearly wants some document, and he's saying this is the sort of thing you should have.
Save that my lord, also, Miss Lawrenson records that that was what he said at a meeting attended by Mrs. Marshall. I anticipate drafting a joint venture agreement. And he doesn't say, as I've said, Mrs. Marshall denied that there was an agreement in place or didn't see the need for that agreement to be drafted. We move on then from June 2019 to the next document which the appellants rely on as relevant, which is a document entitled the Profit Tracker, prepared by Mr. Lynch, the surveyor. That is at page 323. This is a very short document, a single page. It's a simple document. What it does is set out the predicted gross development values for all 4 houses with a range of predictions from low to high. Then in the red text, it deducts certain loans and costs to reach what is termed a gross profit figure. But one can see from the note there would be further expenses, so probably not a proper gross profit figure. That aside, the important line for the appellant's purposes is the next line, which is entitled Partners Split. The figures in that row equate to 1/3 of the figures in the gross profit row. The learned judge rejected this document as being evidence of a pre-existing profit sharing agreement, notwithstanding that line. His findings are in paragraphs 38 on page 36 and paragraphs 58 on page 39 of the core bundle. The finding in paragraph 38 was that this document, the evidence before him, was a long way from establishing that Mr. Lucas expressly approved the content on behalf of the respondents. The final sentence of paragraph 38. And then on page 39, the core bundle at paragraph 58, is the finding that Mr. Lucas simply seeing that document did not establish either that he completely understood it or that he agreed to its terms. In all evidence, there wasn't a great deal between Mr. Lynch and Mr. Lucas. Mr. Lynch's relevant evidence is page 134 of the supplemental bundle.
Was there an allegation that Mr. Lucas was somehow acting as the agent of the defendants?
And that ultimately became established, my lord, not least because Mr. Martin confirmed that he had written authority on the file to take instructions from Mr. Lucas on behalf of the respondents in respect of all matters relating to the project.
Sorry, who? Say that again.
Mr. Martin, the solicitor at
Yes.
Law, had conferred in oral evidence, and this was not known before the trial, that he had written authority on the file to take instructions from Mr. Lucas on behalf of the respondents.
Well, that's very different from agency to enter into a contract. Or, I mean, the question, the more pertinent question, well, I'm not sure how pertinent it is because the pleaded case is 8th of February, but
yes.
To the extent you're relying on this document, profit tracker, which wasn't, there's no indication that it was seen by Mrs. Marshall.
No.
You rely on the fact that it's seen by Mr. Lucas. But what authority is it suggested he had in relation to agreeing a profit sharing arrangement?
It's not made, and it wasn't a pleaded case that Mr. Lucas agreed as agent to enter into the profit share agreement that the appellants alleged was entered into before the 8th of February. I don't rely on the profit tracker as evidencing, as being the agreement itself, if that makes sense, but merely as post facto evidence of an agreement that was reached much earlier. And
so on this document, he's the beneficiary of a third of the profits.
Well, it doesn't.
Having never been party to any of the meetings that took place before about
it. doesn't say who's.
No.
It doesn't say this document.
It's been split three ways anyway.
All that is all the profit tracker shows.
So we don't know. Do we know what he was told about it at the meeting? In the evidence you're about to show us, we'll look at it.
I was taking your lordship's in relationship to page 134.
So this is the evidence
of Mr. Lynch, the
Mr.
surveyor.
Lynch, the surveyor.
And his evidence at D through to H is that the profit tracker was prepared as part of the valuation document and that Mr. Lucas was involved in that process of preparation. And then Mr. Lucas's evidence on this document is at page 155 from around H.
Sorry, when just looking at that evidence on 134, this is Lynch saying we went through it together. Then he says just above E, I prepared the valuation document with Ian mainly. Is this the valuation document or is this something else?
I think, lady, it transpired that the valuation document was a more substantial document.
So that is not what we're talking about.
I am asking about the profit tracker.
Okay. So where's his answer specifically?
Sorry, I thought this was cross-examination, this bit.
Yes, yes. This is...
By Mr. Brown.
Mr. Brown's examination of Mr. Lynch. Yes.
Yeah.
Sorry, did I say I?
Yes.
Apologies.
Yes, that's all right. I just wanted to be clear.
My Melanie, to answer your question, it's the very last answer by H on page 134.
Okay, I'm with you.
So there is a valuation document and then what Mr. Lynch calls a development appraisal, which is the profit tracker document as titled.
So we should look at the answer a date. Okay.
So yes, Mr. Lynch's evidence was that this document was prepared in conjunction with, or that Mr. Lucas was involved with it. Mr. Lucas's evidence on this document is page 155 of the supplemental bundle. It begins at G, my question, to me that time. Over to page 156 at C is Mr. Lucas's confirmation that he would have looked at the document.
It's odd to me, maybe I've misunderstood this, why the bank would want to, why anyone would want to show them the profit share. All they need to know is
I think, my lord, probably correct if I'm wrong, there were ongoing drawdowns and it may be the bank wanted to check its equity position. But I don't know, it wasn't discussed at trial what the purpose of this ongoing preparation of documents, including a profit tracker, was for.
Probably doesn't matter. I mean, they were most interested in the valuation, and that's it, weren't they?
Well, one anticipates, so yes, my lord.
Thank you.
I just then want to flag on page 156 the questions that I asked Mr. Lucas about the partners split line. And I asked him, it's between C and D, do you recall why there is a line entitled partner split? And his answer was no. And I said, perhaps with the benefit of hindsight, that is an odd thing given your case. And he said, in hindsight. So Mr. Lucas couldn't explain why that row was there. In my submission, the profit tracker is a contemporaneous document which was compelling evidence of a pre-existing sharing or partnership arrangement and was thus a document that lay contrary to the learned judge's conclusion about whether such an agreement was entered into. It was therefore incumbent on the learned judge to explain why the document was not to be taken at face value. The only findings which are, or perhaps might be considered to be an explanation for that, is what is said in paragraph 56 at page 38 of the core bundle, which I've already taken the lordship's in relationship to, which is the dismissal of documents because the appellant's side, as I said, I'll come to that as a standalone point shortly. And then the finding that the learned judge couldn't conclude that simply because Mr. Lucas saw the document, he understood it or agreed to it. Clearly, Mr. Lucas had no problem understanding the document when he was taken through it in oral evidence, and that is not surprising given it is a short and simple document.
He doesn't seem to have been asked whether he spotted that line.
Well, I asked him why it was there, and he couldn't remember. He certainly doesn't assert that he didn't see that at the time.
He said that the main point of it was, as he understood it, was to give to the bank so they could decide on drawdowns. That seemed to be his evidence about it.
Yes. Frankly, taken in isolation, it is an odd thing to be there. Obviously, it can be explained by Mr. Lynch understanding that there is a profit split. But then when one factors in that this is a document seen by Mr. Lucas and puts it in the context of what has gone before and what will come following, as I will go through, it has to be addressed by the learned judge in my submission as to why Mr. Lucas has seen a document that contains a reference to a 1/3 partner split, and that is not corrected.
Well,
He was asked for this. I'm just looking at the transcript as it goes on. There was an interruption by Mr. Brown, and then when we go on to page 157 at D, or just above D, you've referred him at C to the figures in the partner split row, and then at D he says he doesn't know why it's there. He accepts at E that it's a three-way split calculation. He doesn't accept anything to do with the partnership, and he says he can't say that I necessarily saw this table at the bottom. So that's something that's got to be taken into account when we assess the judge's finding in 58.
My lord, I would say there's a shift in Mr. Lucas's evidence from initially just saying I would have looked at it to then, once this has been pointed out to him, saying I don't recall it why it's there, I don't know why it's there, and then finally I wouldn't necessarily have looked at that.
Jeanette, would you agree that to disturb this finding you would need to show that there was no evidence on the basis of which the judge could conclude, as he did, which was that he wasn't persuaded that Mr. Lucas saw or really focused or understood that line?
Well, he did find, my lady, that Mr. Lucas saw it, and I don't challenge that.
Saw the document, that's not my point.
Yes.
The point is about the line. I'm trying to understand clearly what you say the relevant test is that we should apply, because normally in a situation like this you'd say, was there some evidence on which the judge could reach the conclusion he did? Well, there's a response, we've just seen it, that Mr. Lucas may not have seen that bit or focused on that.
That was not the learned judge's finding. His finding was that it was seen by Mr. Lucas, but the judge couldn't conclude that Mr. Lucas necessarily understood it. There's certainly no finding that Mr. Lucas did not notice the partner split line, for example.
Can I just ask you this? Your case is that there was an oral agreement back in February 2019, and that was between the one or other of the claimants and the two marshals, is that right?
Yes, my lord.
So Mr. Lucas wasn't party to that agreement, that's no part of your case.
Correct, my lord.
So Mr. Lucas isn't a partner on your case.
Yes, my lord.
He then, suppose that he sees this document that we're looking at, which refers to partners split. What's he to make of that if he's not party to an agreement?
What my client's evidence was, my lord, was that Mr. Lucas was, I think, present at the meeting when my client says the split was agreed, and as I will come on to, Mr. Lucas is later sending emails, given his authority to act on behalf of the respondents, referring to split. So it is...
That's later in the chronology?
Yes. Well, very shortly after February 2020.
Is there anything in the chronology between February, when your client's case is that this meeting took place, and the, where are we now, January 2020, so February 2019 and January 2020, to suggest that Mr. Lucas was aware of anyone saying there was a profit split?
Not a document, no, my lord. Whilst we are...
And so I'm so sorry to...
No, of course.
That this is all, because it is all points of fact.
Yes.
What's the evidence that Mr. Lucas was present when the original agreement was entered?
That's in my client's witness statement. So it's page 36 of the supplementary bundle, my lord. Paragraph 12. After that, I had more than one meeting with Mr. and Mrs. Marshall and Ian Lucas. He's having dining at the hotel. And then from this point, I often dealt with Ian Lucas acting on behalf of his mother and Mrs. Marshall.
One thing I noticed in the judgment is that the judge appears to have accepted, I think, Mr. Lucas's evidence that Mr. and Mrs. Marshall didn't meet Mr. Wynne until March. Are you going to come on to deal with that? Because I couldn't see a specific challenge to that. But it's inconsistent with what you've just taken us to.
Yes, my lady. And there isn't a challenge of that finding of fact. That was a straight conflict of evidence. Where that leaves me.
Well,
quite.
I have to say I'm struggling because your pleaded case is partnership agreement no later than 8th of February. You haven't challenged a finding that they didn't meet until March.
No, my lady. Mrs. Marshall did give evidence that Mr. Wynne had come to the hotel before then. But yes, that her evidence was that...
Well, he must have done to do the bill costings.
Yes.
But it really struck me when I read the judgment to see that finding and it not apparently being challenged. So you need to, seems to me, you really do need to address that.
In which case, I will, my lady.
Yeah.
I mean, the other thing which is closely related to that is that the evidence you've just shown us about there being a meeting with Mr. Lucas is the evidence of Mr. Wynne,
which was not accepted.
Which was not accepted by the trial judge.
And my response to that, Lord, is a short one, which is that his evidence wasn't accepted except where it's corroborated by documents. My case on appeal is that there are a series of documents that corroborate that evidence, and that if the learned judge discounted them or didn't take them into account in reaching that conclusion.
Starting with the 8th of February.
Text message.
WhatsApp message?
Yes.
Okay.
I was going to address, whilst we were on the profit tracker, the second plausibility finding. This was the conclusion of the learned judge that it would have been extraordinarily generous, to quote him, for the appellants to have the build cost, a salary for Mr. Wynne, and a share of the profits, and that such an arrangement would probably have deprived the respondents of the benefits which they had hoped for in developing the hotel in the first place. That is a finding in paragraph 64 on page 39. In my submission, there was no factual basis for the learned judge to reach that conclusion, and actually the evidence before him pointed to the opposite conclusion. I'm about to embark on a small mathematical exercise, but as I've said, under the original plan, Mr. Bygrave was going to pay £750,000 for the hotel. Mr. Wynne told Mr. Opie in his WhatsApp message of the 8th of February, which is page 278 of the supplemental bundle, that it's the second line of the 8th of February main message. The owner owes £375,000 on the hotel.
Hold on.
You might have to take this a little slowly, just so we can get a note of it.
Yes.
So Mr. Bygrave was to pay how much?
£750.
£750. Then OP page...
Page 278, the 8th of February message. And Mr. Opie, of course, is the mortgage broker, so there is, I don't think this figure was challenged, and we have no reason to doubt that the existing mortgage on the hotel was around £375,000.
Yeah.
That's the figure that Mr. Wynne gives to Mr. Opie. So by my maths, under the original proposal of Mr. Bygrave, the respondents would have received approximately £375,000 £5,000. So 750 minus 375 on the existing mortgage. So if we then go to the profit tracker on page 323, the supplemental bundle, and I think I'm right in saying that certainly these figures were not challenged at trial, and given this document was sent to the lender, it's inherently unlikely that these figures were false.
Yeah.
So on the profit tracker, we've got a projected gross profit, using the term loosely, but that's what's said in the document, of between 923 odd thousand and 1.4 million. And
Are you comparing the partners' split to what they would have got on the sale then?
Yes.
You're ignoring, doesn't that ignore, among other things, the financing costs of the build?
They're taken into account when I do. Those are the figures in red on the profit figure. So that takes us from, so the headline gross development value predicted is between 2.7 and 3.2 million. Then what is deducted to reach the gross profit figure are the build cost loan of 800 odd thousand, an initial loan of 580 odd thousand, and then.
But okay, well the numbers don't make sense, but it at least doesn't build in interest. At the very least, the 826 must be the principal outlay. I don't know what the initial loan is if there was an existing 375 mortgage. It's really difficult to do this sort of. Was the judge taken to any of this?
This exercise wasn't carried out by the judge, and what I'm challenging is the finding that it would have been extraordinarily generous and the respondents would have been deprived of the benefit they sought to achieve. My point is that the benefit they would have achieved under the existing proposal was a return of some 375,000.
Yes, but there's always a difference between selling for development, where you get a certain price, but you're leaving the developer, unless you reach a rich arrangement, you're leaving the developer to take the risk, which means profit or potentially loss. It's a very different deal.
But what we know, my client's case obviously is that this agreement was reached in February before the build works start. We know there were costings for what the works were going to cost. We know there were discussions happening with lenders as to what loans were needed. This document obviously comes just shy of a year later, but certainly what it's showing is that at that point it was anticipated that a 2/3 share return would be between 600 odd thousand and 800 odd thousand.
Can you explain where the salary fits into all of this? I've never really understood the salary bit of it. Who's paying the salary?
It came from the marshals, as far as I'm aware.
Right. So it's not accounted for on page 323. It would be a cost for the come out of the share.
Well, ultimately, I
accept, and it's a small point, but I'm just trying to get.
And I accept that this is not a forensic quantum analysis. It's simply a point to say the judge reached a conclusion that there was no benefit in a profit share arrangement, but on figures that were available roughly a year after we say the agreement was reached, the arrangement, even with a profit share, appears to be returning a greater benefit than the original proposal with Mr. Bygrave.
I'm not sure that was really the judge's point, actually. I think the real point the judge was making was, why would you give up the extra bit? It wasn't so much what would they get out of it, it's why would they agree to pay the build costs, which was the JCT amount, it's a contract price, plus the salary, and then give something on top of that. That was really, I understood his point to be.
And if that was the point, my lord, the answer is, well, as my client said, his evidence was that 825 was just the cost. Obviously, there would have been a profit element on that had it been normal contractor employer relationship.
But then this is what puzzles me about this salary, because I don't pay my builder a salary as well as paying him for doing the job. He will take a risk, normally, or she, on whether they're going to make a profit. But that risk is taken out of this equation by the salary. So if you're right that the build contract is mere cost.
I'm not. I have to say, I'm not even clear whether the salary was supposed to be part of the 825 because you can present it as it could well be a cash flow. I'll pay, when I pay a builder, I may pay, for example, against invoices to subcontractors plus an element for the builder. In fact, that's, I think, a normal way to do it, and that's payments as you go along with the building contracts are often signed off by the architect or the project manager.
Payments on account.
Provide precisely that. So I know you've taken us to that paragraph from Mr. Lucas's witness statement, but I'm not sure it addresses whether the so-called salary was part of that, which is a cash flow arrangement within the contract price or something on top.
Which paragraph was it? Can you just remind us? Was it page 71?
Mr. Lucas's paragraphs.
Paragraph 25? Or...
Yes, my lord, paragraph.
Because that actually says, the way it's expressed is in terms of payment, Eamon was receiving £1,500 a week for his works.
But that, it does go on to say, my lord, I remember a conversation between him and my mum where he said that he wasn't necessarily lifting a hammer himself, but that was his salary for supervising, etc. And then
then it'll all be PAYE, and this is all very puzzling. It's not documented.
Yeah, it's consistent. It's also consistent with what I've just said, I think. Yeah. No, you pay your prime contractor something for themselves for having their foreman on site or whatever it is, as well as paying the subcontractor.
So, certainly my understanding is that the 825 was the build cost, so subcontractors, materials, and then this was a payment for Mr. Wynne to be a foreman.
Okay. And how does it fit with the end of that paragraph, which says capped at the agreed total price of 825?
This paragraph melds the salary and then goes on to talk about Mr. Wynne coming each week with a figure to pay on the drawdowns of the JCT. So I think this paragraph, I may be wrong, but I think this paragraph is dealing with two separate tranches of payment. So the salary, £1,500 a week, and then the ascertainment of what Mr. Lucas describes as the drawdowns under the JCT.
Where's the evidence that the 825 was the cost price? I.e., the way you've just put it is effectively subcontractors plus materials.
So the learned judge had some costings that was done by a previous surveyor before him. They're referred to in the judgment. I think they totaled about £850, and then it was Mr. Wynne's evidence that it was cost price. In fact, I'm about to deal with that point now.
Yeah, I think that you were coming to that.
I don't think it appears in the judgment, I don't think the learned judge made any express finding as to whether the 825 figure encompassed a profit element or whether it was pure build cost. As I said, the appellant's case is that it was pure build cost, and there's just a series of documents and evidence I would just take your lordships and your ladyship to.
So you have to say, though, that there's some supporting documentary evidence on that?
Yes, Lord. So the first is a WhatsApp message that you're now innately familiar with on page 278 from Mr. Wynne to Mr. Opie at the outset. And his clear statement in the final sentence of that message, my involvement in this is I have the build cost plus a share of profit.
Yes, the question of build cost depends on depends on whose perspective you're looking at it from. It costs me as a homeowner
more than it costs the builder.
Well, precisely.
I take the point, my lady. I think it is a relatively common term that when something is done at cost price, it emits an element
Okay, I'm
But
not sure you're in
I
a
take-
position of giving evidence.
I am, but I take the point that
Yeah.
build cost.
Okay, so that's your first piece of evidence.
Yes.
You've got other pieces.
The next is Mr. Wynn's cross-examination by my learned friend, where this point is being put, page 127 of the supplemental bundle. And it's most of the page, really from between E and F to G. My learned friend asked if you just read down from B, but my learned friend is essentially putting the point that the judge ultimately found that this was a very generous arrangement. And then at E, why should you also be paid profits? And the evidence was the work, the labour that we charged was at standard rate, like low right, so there wasn't a profit put on it.
Okay.
And then I also raised the point in my closing submissions. And I said I don't think the judge reached a finding as to whether or not the 825 was a build cost or incorporated a profit element.
Well, it's implicit probably in what he did say.
Maybe that's where we differ, because he's drawn a distinction in the elements of the remuneration between the build cost, the salary, and the profit share. And my case simply is that the profit share is the element of profit, and that in finding that it was extraordinarily generous, the learned judge needed to find that that build cost already incorporated an element of profit. Otherwise, there is no profit. Development.
Right, is there other evidence you'd like to take us to?
No, my lady.
So those are the pieces of evidence you rely on. Thank you.
I just want to deal with a short point that doesn't seem to fit anywhere else, but is a finding that was reached in the same paragraph as the implausibility finding. So page 34, paragraph 29 of the core bundle. In the second half of that paragraph, the learned judge finds or accepts Mrs. Marshall's evidence that she wouldn't have agreed anything without the second defendant's agreement. And this feeds into there was no agreement in February because the second defendant, Mr. Marshall, was out at work. The JCT contract is only signed by Mrs. Marshall and Mr. Lucas. That's at page 306 of the supplemental bundle.
Sorry, I'm being. So give me the reference again.
306.
306.
That's the signature page of the JCT contract, and it's signed by Mr. Lucas, Mrs. Marshall, and Mr. Wynn, but not by Mr. Marshall. And I don't know. I need to.
Is he stated to be a party?
He is described as a party on page 302 at the top.
Parties are presumably treating her as signing on his behalf, as well as for herself.
And this is really my point, my lady, that actually the evidence established that Mrs. Marshall did and was prepared to agree things in the absence of Mr. Marshall, contrary to the finding of the learned judge.
Okay.
Just to complete that point, on page 55 of the supplemental bundle, paragraph 21, this is in Mrs. Marshall's witness statement. She gives an explanation of the circumstances in which the JCT contract came to be put before her and came to be signed. She doesn't say there that Mr. Marshall was present.
might be thought there's a difference between agreeing to employ a builder to do some building works on your house and an agreement to give up a third of the profits from a venture of this kind, or indeed to enter into a partnership.
Although, of course, my lord, on the Respondents case, this was the first time that the figure of 825 and the terms of the JCT contract were put before them. So I accept there is a distinction between agreeing to give up a share of profits and entering into a JCT contract, but this is still a serious, on the Respondents case, a serious contractual step and an agreement to divorce themselves of a significant amount of money.
What evidence is there about that? Because, of course, the 825 figure had been around for a while. And by then they had started work on site. Are you saying one has to infer that the builders started work without any discussion about costs?
My case, of course, is the opposite of that. But on the Respondents case, there is no evidence as to when things like price were agreed.
Well, your case is rather a different one, as I understood it, which is that there was just a general agreement in February that the profits, whatever they were, would be shared.
Well, the build cost would be paid, my lord, and the profit would be shared. That's what Mr. Wynne says.
But does he say, and at that stage, the number was discussed for the build costs?
He does refer, and if I take your lordship's lordship back to 278, he does say the build cost is 825k in that message.
Oh, but that's with Mr. Opie.
Yes.
No, I'm asking about whether he says that he discussed it with the marshals.
I don't think Mr. Wynne gives evidence as to discussion as to price.
So there's no evidence from either side about how the 825 was arrived at.
I seem to recall that he gives evidence that the figure was put in because of the figure in the costings, but certainly I don't recall Mr. Wynne giving any evidence, nor the Respondents giving any evidence that they expressly discussed the price before this JCT contract.
Mrs. Marshall gives some evidence
she does.
About it being the costings being 826.
Yes, she does. I was going to ask about that actually. Reading that evidence would suggest that the judge might have ended up with the wrong number at 851.
That was paragraph 17, I think, was it, on page 50?
Page 55.
I think that's simply quoting in the reply. I'm not sure that's direct evidence from Mrs. Marshall. Page 54, 55.
So this is her witness statement.
Yes, my lord.
Oh, I see. You're saying that quote.
And then, my learned friend rightly points out on page 56, paragraph 22,
Well-
my lord.
Well, hang on,
Yeah.
we got financing on that basis. So they actually got the financing through
Through
Mr.
Mr.
Opie.
Opie. Yes, and made on the basis of the costings prepared by Mr. Fairweather, which there's some discussion in the transcript between myself and the judge because my maths was wrong, and I think the figure in the costings was around 850.
So are we saying the reply was wrong at 826? Are you saying the reply was wrong?
I'm afraid I don't. The costings are not in the bundle, so I don't think I can assist in that precise point.
It says they're in the statement of reply, so we've got that, haven't we?
Yes. I don't know if before I do that, your lordship wanted to look at paragraph 22 of Mr. Marshall's witness statement, which just explains her understanding of the 825 figure in the JCT.
Sorry, where are you?
Page 56, paragraph 22.
56, 22. Yes, this is my point as to why the judge discusses 851 rather than a figure which is much closer to 825.
That the figure of 851 came from Mr. Fairweather's costings that were in the bundle. I don't know if there were more. I can't remember now if there were more than one set of costings, but certainly the costings that were in the bundle, the sum total for each. I think, as I remember, they were split into each property and then with some general.
Okay,
costs.
but Mrs. Marshall in her witness statement is saying actually the final costs were 826, and that's what the reply says. Sorry, I'm probably missing something here, but
there's a figure of 826 in paragraph 5 of the reply, which is a figure that emanates from Mr. Fairweather after the grant of planning consent.
Yes, I think that is in an
826.
testing. I think that was in an email. There was an email reference from Mr. Fairweather, but then what the learned judge had before him were the detailed costings. I'm afraid I cannot remember the chronology, whether the email came before or after, but certainly the learned judge before him had Mr. Fairweather's detailed costings per plot, and the sum total was 851.
oh, I see.
Oh, it looks as though, if you look at paragraph 6, I'm just doing a quick bit of
Assisting.
mental arithmetic, but I think that comes to about 850.
Yes, my lord, precisely right. So yes, that is right. So there's an initial
So that's presumably
email.
where the 850 comes
Yes,
from.
and then some months, a couple of months
Okay,
later.
well that's quite that is relevant because the 825 is closer to the cost being suggested at January 2019, and therefore is pretty consistent with the email, the WhatsApp message on which you rely. But then it looks like the costs go up a bit by May.
Yes.
But the actual JCT contract sticks at 825.
Yes.
Okay, I think I understand a bit better now.
Okay, so the proposition is that the judge could not properly find that it was extraordinarily generous unless he made a finding that the build cost included a profit, and there was no evidence to support that
Yes, my lord.
conclusion.
Yes, my lord. And I was just making the out of place point about Mrs. Marshall not agreeing anything in the absence
Yes.
of Mr. Marshall.
Then we just went back to the other point.
Yes, just to conclude that point, I just wanted to show your ladyship and your lordships Mrs. Marshall's cross-examination and her answer on that precise point, which is page 179. So 179F. I've taken Mrs. Marshall through the JCT and it not being signed by Mr. Marshall, then I say, or I ask her whether she was happy to agree contracts relating to the development without Mr. Marshall being present. Mrs. Marshall nodded. My learned friend helpfully said the transcript can't pick up nods, and then there is a series of questions. And then right at the bottom of page 179, I ask again, were you happy to agree contracts without Mr. Marshall being present? And she says yes. So I say the learned judge finding for his apparent acceptance of Mrs. Marshall's evidence that she wouldn't have agreed anything absent Mr. Marshall, and therefore could not have agreed in February 2019 to a profit share because Mr. Marshall was out of work, was simply wrong on the evidence before him. I move now from the profit tracker in January 2020 to exchanges between solicitors instructed by both sides, which begin in February 2020. So Miss Parslow of Temple Bright Solicitors is instructed by the Appellants, and Mr. Martin of Converse Law Solicitors is instructed by Respondents from around February 2020 into 2021. Some of these documents are discounted by the judge as coming from the appellant's side, but some are not. There are 4 relevant exchanges, 4 points in time between February 2020 and July 2021, which I will deal with in turn. The first exchange is the emails in February 2020, which are at page 324. Again, we have reverse chronological change. So the first one in time is at page 328. This series of emails arise in the context of a proposal for further financing of the development. And your Lordships and your Ladyship can see from page 328. Goshawks, I think, were acting for the proposed lender. So it's Mr. Claxton from Goshawks who sends the email. And it refers in paragraph 1 to a loan facility agreement, and then paragraph 2 to security being granted over the hotel. And then at paragraph 3, a third party mortgage being granted over Mr. Wynn's personal property. And then we go slightly forward in time, and there's some back and forth between Goshawks and then Miss Parslow and Mr. Martin. And then I want to take your Lordships and your Ladyship to page 325. Which is in the middle of the page, Mr. Martin's email to Mr. Parslow on the 26th of February 2020. And Mr. Martin's second paragraph, also I understand that a profit share arrangement is required. Are you happy to work with the attached precedent?
I've lost that.
Middle of
the page, my lord. Sorry, it's
I see, yes. I was looking at the other email.
Understand.
Right, so 26th of February.
And again, as I did previously, I will just go through the chronology and then make submissions as to what we show and what the merchant will do.
Yes.
So then...
was that attachment in the bundle?
No, it wasn't, my lord.
Was it at the trial?
No, it wasn't, my lord. I don't think it's been... I certainly haven't seen it.
All right.
So up the page, bottom of page 324 into 325 is Miss Parslow's response asking various questions. And then up to the middle of page 324 is Mr. Martin's reply on the 27th of February, where he has taken Miss Parslow's questions and then given responses. And finally, at the top of the page, Miss Parslow replies and says, Matthew Amon approved the terms below. Just focusing for the moment on the email in the middle of page 324, so Mr. Martin's email at 1448.
Sorry. Matthew Martin is for
the respondent.
the respondent.
Just to confirm for your Ladyship and Lordships the origin of what is in this email, 1448 email, if I could take your Ladyship and your Lordships to page 206 of the supplemental bundle. Mr. Martin's representation by me, and on page 206 at F, Mr. Martin confirms that he sent Miss Parslow's queries to Mr. Lucas. This is from G onwards. Mr. Lucas responded with answers to Miss Parslow's questions, and then Mr. Martin effectively copy and pasted that into his 1448 email that was sent to Miss Parslow. just to make good a point I made earlier, on page 209G is Mr. Martin's confirmation that he had authority to take instructions from Mr. Lucas on behalf of Mr. and Mrs. Marshall. And that's at G on page 209. Just going back to the learned judge's conclusions in respect of this email.
I'll just ask you a question just before you do that,
Yes.
about the terms of the email at 324,
Yes, my lord.
where it says in the middle, who doing what, EJW builders are building and putting in funds. Do you see that?
Yes, my lord.
Now, at this time, they were talking about raising new funds, including Mr. Wynne giving some security, personal security over his own property, third-party security.
Yes, my lord. Well,
Up until this point, sorry, I interrupt you.
I was just going to say, I think the learned judge's understanding, and I don't demur from it, is that the loan was being taken from the Marshalls and then there was third-party security being offered by Mr. Wynne.
Right. Now, up to this point, so before February 2020, what was the evidence about what the appellants had put into there?
So you see some of it in that email, my lord. So just a reminder that the contents of this email come from Mr. Lucas, and the final question Miss Parslow asks is who is putting what monies in, and then there is a list of items, and we see interest from Lowry loan, interest from William Allen loan. I will come to this, but Mrs. Marshall's evidence and also Mr. Wynne's evidence is that they were loans he had taken to fund the development, and then we see an initial investment of 20,000.
Sorry, the Lowry loan and the William Allen loan, who took those?
Mr. Wynne or his company.
And then there's a £20,000 initial investment, is that right?
Yes.
All right.
And I was just going to refer your lordships and your ladyship back to the judgment and a finding made by the learned judge about this email, which is on page 36, paragraph 40. And the learned judge refers to the email of 27th of February regarding expected profits, and then says this was information which was not provided by the defendants. But of course it was information provided by Mr. Lucas acting with formal authority on behalf of the defendants, and that point is not referred to. Ultimately, the learned judge's conclusion on this chain of emails was that they were not relevant because all they did was record a proposal that was under discussion that was prompted by the new security arrangement that ultimately fell through. That conclusion is on page 39 in paragraph 59 of the judgment. The judge clearly found that what was put into that email didn't record a past agreement, it was in relation to a future proposal and was contingent upon a refinancing which fell through. In my submission, if that conclusion is right, that these emails in February 2020 only evidenced a future proposal contingent on the security arrangement, then logic would dictate that there would be no further discussion of a profit-sharing arrangement after the security proposal fell through. And And Mr. Martin's evidence in cross-examination was that the proposal, new security with the third-party mortgage against Mr. Wynn's property fell through very shortly after that exchange. I can take a completeness, that's page 208 of the supplemental bundle. At 8 at the bottom of the page, I asked Mr. Martin when the TFG capital proposal fell through roughly. And he says, I think it was essentially at the meeting I had with the client to go through the advice. I say the following day, and he says, I think it was. I don't think we ever get a precise date. I go on to say in February of the page, and he says yes. So on the respondents case, and as the learned judge found, there was discussion of a profit sharing agreement in February 2020, but only in relation to a security proposal that had fallen through in February 2020. And my submission.
The judge accepted, though, Mr. Martin's evidence on this point, didn't he? Because Mr. Martin actually said, I didn't think there was a existing agreement. I thought this was all about some new agreement. That was his evidence, and the judge has accepted.
He accepted what Mr. Martin thought, yes, my lord.
So the point you've just made might have been a good point to make to a trial judge about why the judge oughtn't to accept Mr. Martin's evidence, but he has accepted it.
But of course, he can accept what Mr. Martin thought, but that doesn't change the issue, which is, was there an agreement that was entered into in February 2019, as the appellants alleged. It may be that the February 2020 emails aren't taken to be evidence of that prior agreement, but if they're taken in accordance with the learned judge's finding that the profit sharing arrangement was only discussed in February 2020 and only in relation to this proposed financing that fell through, and as I say, that really begs the question in respect of subsequent emails that I'm about to come on to, which the learned judge didn't address, as to why, following February 2020, there continue to be discussions between solicitors instructed by both parties about a split of the net profits.
Okay, you're taking us to those now.
I am, yes, my lady. So this is the exchange in June 2020, so some 4 months later. It's at page 335 going into 334 of the supplemental bundle. The first email is the one at the very bottom of 334 going on to 335. This is the 11th of June 2020 from Miss Barlow to Mr. Martin. She says in her second paragraph that she's had a call from Mr. Wynn and that Mr. Wynn's anticipating Mr. Martin drafting something that Miss Parslow will need to review. And then Mr. Martin's response is in the middle of page 334, also on the 12th of June. And it's his second paragraph which is key. I spoke with my client sometime last week, and in cross-examination, Mr. Martin confirmed that the reference to my client here is Mr. Lucas. And he asked for something to evidence the split of net profits from the project in Trowbridge. My client said he will email details of agreed deductions which can be incorporated into a letter to be signed by Mr. and Mrs. Marshall, Ian Lucas and Eamon. Once I have those details, I'll be in touch so we can agree the form of a letter document. At the time of speaking to my client, I said it would be advisable for Eamon to get back in touch with you, so I'm glad he has. Understandably, this exchange was put to Mr. Martin in cross-examination, and his evidence on it is at page 210 of the supplemental bundle, 209. 209F is the confirmation that the reference to my client is Mr. Lucas. And then I asked Mr. Martin what he recalled about the conversation conversation he referred to having with Mr. Lucas the week before that evening. And his answer is, I think I was looking for some certainty so that the document could be drafted, and I asked which document, and he says any kind of profit share proposal. And then I put the point that I'm making now. Well, on your evidence, the profit share proposal was linked to the TFG capital proposal, and that had fallen through in February, to which he agreed. And when I asked, do you recall why there were still discussions happening about profit share arrangement, he wasn't able to remember. And then at D, I say, it appears from what you say in your second paragraph that you had been instructed by Mr. Lucas to draft a document recording a profit share arrangement, and Mr. Martin agreed with that. So going back to the emails at 334, 335, this is an objective exchange between two solicitors representing both parties, so it isn't tainted by the learned judge's finding of documents being from the appellant's side. It is, in my submission, compelling evidence of profit share, and it's also a document that is unexplainable on the respondent's case and the learned judge's finding that a profit share was only discussed in the context of the February 2020 security arrangement. So, turning to the way in which the learned judge dealt with this exchange, I want to firstly mention its omission from the chronology. If I could take your lordships and your ladyship to page 36 of the core bundle in the judgment. We see it, paragraph 40, a reference to the February 2020 exchanges, and then paragraph 41 jumps to July 2020, so no reference to the emails in June 2020. And then explicit discussion of those June 2020 emails is on page 39 at paragraph 60 of the judgment. And the learned judge's comment on the email exchange in June 2020 is that the agreement was, quote, too easy to need a draft. The learned judge did refer to Mr. Martin's inability to explain that document, but in my submission the learned judge went on to then supplement his own view, not a view that any of the witnesses had ever expressed. The view that document was too easy to need a draft ran contrary to, firstly, the contemporaneous opinions of two solicitors, so Mr. Martin and Miss Parslow, who'd both had discussions, both in February 2020 and now, about drafting a document. And of course was contrary to the contemporaneous opinion of Mowbray Woodward back in mid-2019, who also considered that a document needed to be drafted by solicitors. So simply put, it was no one's case on the evidence that the arrangement was so easy it didn't need to be put in writing. In fact, the appellant's case throughout was, I was trying to get this into writing. What we also don't have in paragraph 60 is any engagement by the learned judge with the wording of Mr. Martin's email. That email refers to, quote, agreed deductions. The only possible construction of that email is that what Mr. Martin was being instructed to prepare was a letter or a document expressing agreement as to figures. So what costs would be factored in to reach the net profit figure. If the only arrangement in place between the parties was a JCT contract with a price provided for, it would be entirely unnecessary to ascertain what the net profit was, at least with Mr. Wynn's involvement, and what deductions needed to be made to reach that figure. None of this was considered by the learned judge. have an eye on the time, lady, my lord. I think I can get to the end of the Temple Bright Converse Law exchanges by the lunch adjournment, so I'll
Yes, thank you. Well, we've been interrupting quite a lot, but I think it's been productive from our point of view.
I expected nothing less, my lord, and I'm grateful. So I want to move then. The next exchange between the solicitors is in February 2021. That is pages, continues in the train we were on, in fact, 334 up into 333 of the supplemental bundle. At the same time, there is an exchange just between Miss Parslow and Mr. Wynne. Those are the emails at 331, 332. And we see at 331, on the 18th of February 2021, Miss Parslow refers to having spoken to Mr. Martin. I asked Mr. Martin about that conversation in cross-examination, and his evidence is at page 211. And just above F, E through to F. I asked him about Miss Parslow saying that she'd spoke to Mr. Martin. I asked him if he recalled what was discussed. And his answer was, I believe it was discussing evidence of what costs have been incurred or what costs are to be incorporated into the agreement to, and then I rudely interrupt, and he says, carries on, to actually make the agreement work. Without detail, it just wouldn't have been viable.
To make what agreement work? Do we need to read more context?
Yes, Lady, I think perhaps carry on. The very bottom of page 211, the final sentence. So no specifics that I remember, but either which way, both Claire and I are discussing how the profit share agreement, what information we would need in order for something to be put together that would stand any chance of enforcement. And I say, well, when you say what costs that need to be incorporated, is my explanation right, that what you're ascertaining is the deductions before you reach a net profit figure? Mr. Martin says, well, indeed, insofar as the original proposal setting out heads of terms. I understand that to be a reference back to the February 2020 email, which, as you recall, Miss Parslow asked for heads of terms, and the response comes back.
Okay, so your starting point is you simply can't dismiss the February 2020 email by reference to the proposed security because the proposal clearly survived.
2 points made. One, it's still being discussed, and that continuing discussion is not explicable by the learned judge's findings, that this all came to an end in February 20. And secondly, Mr. Martin's own evidence, when being asked specifically about emails in 2021, loops back to what is in the February 2020 exchange with Miss Parslow and the heads of terms there.
When you say the judge's finding, you're talking about the last sentence of paragraph 59 of the judgment. The proposal fell through after Mr. Martin advised the defendant on that proposal. Was there more to it than that?
So paragraph 59, my lord, is the learned judge's rejection of the relevance of the February 2020 emails.
Yes.
It's the point he says in the context of recording the proposal. That's the bit you're focusing on, really.
Yes, my lady.
That's how you're saying that's how he explains it, but he couldn't explain it on that basis.
Yes, maybe for the 2 reasons I've just outlined.
Yeah. In the context of recording the proposal that was then being put forward. Yeah. Okay. Thank you.
So again, this exchange in February 2021, both the documentary evidence and Mr. Martin's oral evidence is, again, as I say, objective, not tainted by this concern about documents or evidence only coming from the appellant's side, and is once again compelling evidence of a profit share agreement already being in place, and again cannot be explained in the context of the finding that in February 2020 any discussion about a profit share came to an end. The learned judge's findings specifically on these February 2021 emails are on page 39 of the core bundle at paragraph 61. He says, the 7th documents of the emails of February 2021, Mr. Martin thought that this was just agreeing what cost was to be reimbursed, and I can see that is quite possible. My first point that is a misquotation or a misunderstanding of Mr. Martin's evidence. I've taken your ladyship and your lordships to Mr. Martin's cross-examination. His evidence was the discussion about costs was about deductions to reach a net profit figure, not about reimbursements. And secondly, and most importantly, and I've already made this point in respect to the June 2020 emails, this finding of the learned judge that there was an agreement or a discussion about agreeing costs to be reimbursed in February 2021 is wholly incompatible with the conclusion that the parties' relationship was only governed by a JCT contract with a specified price of £825,000 for the works. If the learned judge was right that the JCT contract with that specific price was the only agreement between the parties, there would simply be no need for a discussion about reimbursing costs or incorporating or deducting costs to reach a net profit figure. And that incompatibility is not engaged with in the judgment. There is no explanation of how these emails in June 2020 and February 2021 fit with the primary finding that the JCT contract was the only contract. The final email is at the top of page 333 of the supplemental bundle. This is an email from Miss Parslow on the 1st of July 2021 to Mr. Martin. Miss Parslow notes that Mr. Wynn's understanding is that some of the properties are about to be sold and asks for confirmation of how Mr. Wynn will be paid his share of the profit on the sale of the properties. And she refers to the agreement between the parties as per the attached email, and the attached email is the February 2020 exchange. It's fair to say this email was not responded to by Mr. Martin. What follows is what is at page 336 the next day, which are the letters from Whittle and Co surveyors purporting to terminating the JCT contract. Mr. Martin was asked about the 1st of July email and cross-examination. His evidence is on page 212 of the supplemental bundle. Begin by quoting the email at C, and then I ask him to confirm that the attached email that Miss Parslow refers to is the February 2020 exchange, and he agrees with that. That's at F. Confirms he didn't reply. And I ask him why he didn't reply, saying, what are you talking about? Mr. Wynn's not going to be paid a profit share. We've never reached an agreement. And his answer at H is that I understood Mr. Wynn had left the site in June 2021, and therefore I believe that the whole deal was off in that respect. That explanation, in my submission, rests on there being a deal in the first place, which is precisely the appellant's case. Again, we don't find a discussion of...
Well, can we just pause on that? Solicitors will conventionally talk about the deal being off when they've been trying to reach agreement and nothing ends up being agreed. It's common terminology. So it could mean a number of things. It doesn't necessarily mean, surely, that there was a contract.
I say against the background, it must do. The point that what is being discussed in June 2020 through to 2021 is not so much documenting the terms of the profit share, but agreeing figures, as I've said, from June 2020. I don't think that Mr. Martin's words here are going to decide this appeal for me. It's simply an observation. And perhaps the more important point is that his evidence is not considered by the learned judge in his judgment. There is no analysis at all of the 1st of July 2021 email or the oral evidence given in respect of it. That email is dealt with at the tail end of paragraph 61 on page 39 of the core bundle. And it's briefly dismissed on the basis...
That's document number 8, yeah. So
yes, lady. And it's dismissed on the basis that the earlier February 2021 emails are dismissed under what I've called the self-deception finding, that all it shows is what Mr. Wynne had convinced himself of. And I will come to this self-deception finding probably.
Well, is that what he's saying? There is a finding of self-deception. But all the judge is saying in 61 is that the documents don't show that there was anything other than a contract which the claimants thought had been agreed. It's consistent, isn't it, with the finding that there have been suggestions that there should be something more, aspirations to put something further and different in a document, and it didn't come to anything.
Yes, I think that was the finding, Lord, yes, yeah. I agree. But that is the finding that I'm attacking on the basis that a proper analysis of the June 2020, February 2021 and July 2021 emails could not have led to that conclusion.
I'm just trying to distinguish that from a sort of fantasy that something happened in February 2019 that just didn't.
It's in my submission difficult to reconcile, and I said I'll come to this, but it's difficult to reconcile Mr. Wynne having a fantasy that isn't corrected at any point, and which both sides are presumably paying and engaging solicitors to continue negotiating at a point where, on the learned judge's findings, there is no more discussion about a profit share.
Yes, thank you. It's missed on the same basis.
The final implausibility finding is probably sensible to deal with at this point, which is the learned judge's finding that it was implausible that the respondents would want to share the profits of the development at all, given the point of the development was to finance their retirement. That's a finding that's in paragraph 29 at page 34. My retort to that is simple in that...
Sorry, paragraph
29, my lady, on page 34.
Yeah. Yeah.
That conclusion in my submission wasn't available because, of course, the learned judge found that there was a discussion about profit sharing in February 2020, albeit in a specific context. So even on the learned judge's construction of February 2020 exchanges, it is clear from the content of those emails at a time when the respondents were being advised by a solicitor that they had no principled objection to profits being split. There is just one final point on these exchanges, which I think will bring us nicely to one. I don't know if this is still advanced. It was a point run by my learned friend at trial and is repeated on appeal, that there is some weight to be given to the inclusion of the word subject to contract in the February 2020 exchanges. I just call back up page 328 is in the supplemental under 328, the original email from. So this is the start of the chain. This is the email from Koshorp talking about the lending proposal, and that is where the word subject to contract first appear in the subject line.
So you're saying it's from the lender's solicitors?
not just me, my lady, if I just refer your ladyship and your lordships to an exchange that I had with the learned judge in closing submissions about this very point, page 226 of the supplementary bundle. And it's at H. I make the point that I've just made now, and the learned judge says this is just a takeover of somebody else's heading, is it not? And I agree with that. And obviously, that there's no discussion of the subject to contract line in the judgment as affecting it. So I just think that wasn't a good point then, it isn't a good point now. That brings me to the end of the chronology. Sadly, not to the end of my submissions, but it may be an appropriate time to pause.
How are we doing on timing in your own view?
I would hope, my lord, not to be more than another 45 minutes.
Yes, thank you. 2 o'clock.
All rise in favour.